So you're already dealing with everything that goes with the death of a loved one, and you get a letter in the mail that shocks you. It says that your accidental death insurance claim has been denied based on a drug exclusion. Well, the drug exclusion is one of the insurance company's favorite exclusions to try to get away with not paying the claim that you're entitled to receive. Automobile accidents, bad falls, and drownings are some of the most common types of accidents where we see insurance companies raise the exclusion as a defense. Well, one thing to keep in mind, if you've been denied a claim based on an exclusion, do not give up. The insurance companies are often wrong, and you can prove them wrong either on appeal or in court if they deny your appeal. Hi, I'm McNamara. I spent years representing the insurance companies before quitting that to use the knowledge I gained there to represent people against insurance companies when they deny insurance claims. Insurance claim denials are 100% what we do in this office, and we handle these claims every day. We'll go through the steps that we take to appeal a denied claim that we call our Win My Benefits process. Step one in this process we call gather. In that step, we gather all evidence known to exist that we can look at that could help potentially prove the insurance company wrong in denying your claim. It begins with a request to the insurance company that they produce their entire claim file to you as a claimant and beneficiary. They're required to give you the file by law, and if they don't give it to you timely within 30 days, they incur penalties. You should make this request in writing so that it's of record, and when you get that claim file, you need to go through every page, and it will have things like toxicology reports, police reports, ambulance reports, first responder reports, witness statements perhaps, and it will shed light on what the insurance company's reasoning was, what experts it may have hired to look at the facts and support their conclusion that the exclusion applies to your case. And it'll also include the insurance policy and any denial letters or prior versions of the denial letter before they sent it to you. So you need to get all this evidence together so you can see what the insurance company is relying on to support their denial and what evidence might be in that same record that will support your position that the denial based on the intoxication exclusion was wrong. Step two in our Win My Benefits process is to organize. And what I mean by that is when you get the claim file from the insurance company, you're going to find that it's a disorganized mess. There's going to be duplicate pages, there's going to be blank pages, and it might be anywhere from several hundred to several thousand pages of records. What you need to do is take that file, organize it, tab it, make basically an index of it, sequentially page number the entire file, put it into a computer program that lets the text be searchable, and that way you're going to have sort of a roadmap of exactly what exists in that record, and it's going to be useful for you when you make your argument appealing the denial or later making your argument to the court, where you can in a very organized fashion cite to a specific case number within that big file where the court or the insurance company during your appeal can follow exactly what you're talking about and look at the documentary evidence very easily as they go through your argument. Step three of the Win My Benefits process is analyze. And by that I mean you look at the denial letter, read it very carefully, see exactly what the insurance company is saying are the reasons that they're denying the claim and why their drug exclusion applies. And then look at the actual policy language and see if the policy language in the actual insurance policy is the same as the language that the insurance company is quoting to you in the denial letter. Now, assuming they match up, then look at whether or not the exclusion is one that excludes deaths that are caused by the actual drug itself, as in a drug overdose. Some policy exclusions exclude death involving drugs only if the drugs actually caused the death, as opposed to causing an accident that ultimately leads to death. Other exclusions in different policies do exclude deaths that are caused by injuries when the drugs in a person's system caused the accident that produced the injuries, even though the drugs themselves, in and of themselves, didn't cause the death, as in an overdose. Well, even when you have a situation where a person dies in an accident, where the insurance policy says that if drugs in their system are an overdose of drugs, or taking drugs that are not prescribed by a doctor or that exceed the amount that's prescribed by the doctor. If a person's in an accident, let's say it's traffic signal automobile accident, and the person who dies and has ultimately found to have drugs in their system has a green light and is T-boned by another driver who has a red light. Well, obviously, the drugs are not what caused that accident, whether it was an intoxicating amount or not. What caused that accident is the fault of the other driver in running the red light. But you can rest assured that if drugs showed up in the system of that person who had the green light and died in that accident, the insurance company's going to still deny the claim that the drug exclusion applies, and try to avoid paying the benefits that are due. So you can see why the specific language of the policy exclusion is critical. You can see why different fact scenarios can lead to different conclusions and different arguments about whether the drug exclusion should apply. And what we also do is look into the federal case law, and we look at cases where courts have interpreted exclusions worded just like the one that our client's policy has, and we see how the judge interpreted that policy under a given fact scenario. And we also try to find cases with fact scenarios similar to ours, and then we can use those cases to support our position that a drug exclusion under a certain set of facts and written a certain way should not apply to a given case where the insurance company denied the claim. Step 4 in the Win My Benefits process is to build. And by build, I mean you look at all the information you got from the claim file, from what you've studied about the policy language, what you know about the facts, what you know about case law that has been decided before a certain way based on similar policy exclusions and similar sets of facts. And you decide what can you gather and put together that may not be in that claim file, but that supports your view that the policy exclusion shouldn't apply in this case. That may include medical records of the person who ultimately died, but before they died and after the accident, or it could include medical records that were maybe prior to the accident itself. It might also include hiring a toxicology expert to make a determination of whether drugs in the person's system actually caused the death, or whether drugs in a person's system was likely to have caused an accident that led to a death. And you take all of this information and put it together in an organized way that the next thing you can do is execute on it. And by that I mean creating your argument using everything you found, law in your favor, facts in your favor, and putting that together into a comprehensive appeal package to. Step 5 in the Win My Benefits process is to execute. And by that I mean you take all of the evidence that was in the original claim file, the insurance policy exclusion provision, the denial letter reasons, and then the evidence that you've built or created and added to what the insurance company didn't have. That might include the report from an expert you hired. It might include other witness statements. It might include other medical records. It really just depends from case to case. But you take that and the case law that you've reviewed, and you weave that all together into your best argument, factually and legally, why the insurance company was wrong in their denial, why you are right and entitled to benefits, and you submit that to the insurance company. You wait for them to rule on the appeal, and sometimes they'll grant the appeal if you convince them that they're going to lose if they take it to court. If they deny the appeal, your work was not for nothing, because now you can use all the work you put into this, all the evidence that you've built up, and that's going to help you try to convince a judge in federal court that they were wrong in continuing to deny the claim. So final thoughts. It's really impossible to generalize exactly how you would build evidence to fight a claim denial under an intoxication exclusion, because the facts are so different. The insurance policy's provisions and exclusions are so different from case to case. And I would say the best thing to do is, before you create your appeal, before you talk to the adjuster, before you do anything, you can download our free book. It's on this website, or you can get it at winmybenefits.com. And it's our book, How to Win Your Accidental Death and Dismemberment Denial Appeal. Read that. It's full of information. It makes you aware of the traps and the tricks that the insurance company will try to play with you on the way, and how to avoid those. And it gives you a broad overview of how the process works in general, the timing of it, the deadlines, and other important things that you need to know if you're going to handle one of these claims. If you'd like to talk, better yet, give us a call, and we're happy to talk to you about your claim. It's free of charge, no cost to evaluate your denial letter, and we love helping people with these. We'd love to help you any way we can, and I appreciate you listening to this. I hope it was helpful. Have a great day.